This is the OPE review of evidence. Under 801, excluded from hearsay are adoptive admissions and opposing party admissions. 804, hearsay exceptions, the unavailable declarant, that's 804, former testimony, dying declaration, statement against interest, statement against party who caused declarant's unavailability. Regards to dying declaration, only admissible in homicide and or civil cases. Declarant need not die, but must be unavailable. 803, hearsay exceptions, unavailable declarant immaterial, includes present sense impression, excited utterance, statement of emotional physical condition, statement for medical diagnosis treatment, recorded recollection, records of regularly conducted activity, public records, and learned treatise. Looking at the excited utterance, this is where you say, quote, "I'm dying, don't let Leah get away with it," end quote. This is a startling event and or condition and made well under the stress and or excitement that caused it. Statements for medical diagnosis and or treatment. This is statements of medical history, symptoms, sensations, inception, and or cause. This includes statements made to primary doctor as well as those brought in to consult. Recorded recollection must first lay a foundation for documents to be admitted. You must establish insufficient recollection to testify fully and accurately without the notes, and that the notes are an accurate reflection of knowledge when the matter was fresh. Looking at learned treatises, a statement from the treatises may be read into evidence. They may not be received, the treatise may not be received as an exhibit. It's not allowed, the jury is not allowed to bring the treatise into the jury room. Moving on, looking at experts. You may rely on hearsay informing their opinion if other experts would reasonably rely on such information. Character evidence, prior bad acts under 404, they must bear on truthfulness. They are admissible to prove the defendant's conduct if offered for some purpose other than to show the defendant is a bad person. Where similar acts are in dispute, they may be admitted to prove intent, knowledge, lack of accident, and modus operandi. They can be offered, bad acts can be offered as proof the defendant committed the crime charged. Character evidence, or character may only be proven, as per the federal rules of evidence, by reputation or opinion. Specific instances of conduct may be allowed where character is an essential element of the claim and or charge or defense. Impeaching a witness. So impeachment goes to witnesses, character evidence goes to a party to the case. So impeaching a witness, this is impeaching them with past convictions. These are admissible if the crime involved dishonest acts, false statements. Impeaching a witness, an ability to perceive and or remember. Drug or alcohol use at the time of perception is relevant and may be used to impeach the witness. You're going to have privileges. You have a spousal privilege, and this encompasses testimonial and communication privilege. Testimonial privilege applies only in criminal actions. They must be married at the time of trial. Testimonial privilege is held by the witness spouse, and the defendant spouse cannot prevent testimony. Looking at privileges and spousal communication. These are communications, confidential communications during marriage. This applies to both criminal and civil proceedings. This privilege survives the marriage, and it's held by both the witness and the defendant spouse. Looking at privileges and attorney-client privilege. This applies to confidential communications made for the purpose of facilitating legal representation. Fee agreements and payments are not protected. Attorney-client privilege can be invoked where it conceals evidence of a past crime. Now, attorney-client privilege and the work product doctrine, these are materials prepared in anticipation of litigation. They're subject to discovery on a showing, only on a showing of substantial need by the other party and an inability to obtain substantial equivalent by other means. Claim of work product must be asserted in front of and ruled on by the court. We got to notice facts in criminal context. Looking at jury instructions, a jury may and or may not accept notice facts as conclusive. This allows the court to instruct on permissible inferences. Quote, you may but are not required to find, ... end quote. Statements made in negotiations. There must be a dispute. This does not mean that there has to be a filed claim or a court action. It just requires a dispute between the parties. The statements made in negotiations. Probative value of the evidence is for the jury to determine. Evidence where this is an example is where the evidence is not very strong. A man is arrested with a knife that matches wounds of the murder victim. No other connection. He's charged with murder. Probative value of that is for the jury to determine. Destruction of evidence. It's proper inference for the jury that the evidence would have been or was adverse to destroying party's case. Asserting the Fifth Amendment in civil cases. It's proper for the jury to draw an adverse inference from the party's assertion. Customers' letters, this is just kind of general stuff taken from the questions. Customers' letters to a manufacturer warning of possible danger. Those letters are not hearsay if they're offered only for the limited purpose of proving the manufacturer was put on notice of possible danger. The letters would be hearsay if offered to prove the assertions contained in them. This is where the defendant is charged with knowing possession of a stolen television. The defendant offers a statement of a friend who gave her the TV. The statement is to a neighbor, a third party. The TV was given to her by her mother. This is hearsay to prove the friend actually owned the TV. It's not hearsay to show the defendant thought the friend owned the TV. Hearsay exception out of court statement and prior identifications. This may be admissible where the declarant is testifying and subject to cross. Again, hearsay exception to out of court statements in regards to prior identifications. It may be admissible where the declarant is testifying and subject to cross. Must have sufficient personal knowledge. This is a very low bar. The question was evidence of defensive wounds indicating the declarant saw the attacker. Again, evidence and a trick question. Now, facts may look like they are trying to admit a past conduct to impeach the character for truthfulness, but they are in fact using the past conduct to contradict prior testimony elicited on direct evidence. On direct exam, sorry. And that completes OPE review of evidence.